Thank you. Welcome to the forum. I'm sort of a stranger here myself, so you should be welcoming me rather than the other way around, but we'll make it work. I do want to say I see some people standing or still getting food in the back. There are a number of seats here in the front, so please don't hesitate to come forward. We'll feel more comfortable if we don't have the sense that everybody's avoiding us. So, in any event, this is a forum on the Supreme Court, last year's term and this, but we're not going to follow those instructions exactly. Last term was a relatively uneventful term. They had only 8 justices much of the time. The docket was thin. And the term ahead of us is filled with a number of extremely important and interesting cases. So what we're going to do is talk about the term that is to come, but when we have time for questions and comments from the floor afterwards, you should feel free to ask or comment on cases from last year as well. Allow me to introduce the 3 panelists this afternoon. On my immediate left is Melissa Arbus-Sherry. Melissa is the deputy head of the Latham and Watkins office in Washington, D.C., and fairly recent alumnus of the United States Office of Solicitor General, where she served for 5 years. She's argued 10 cases in the Supreme Court. On her left is Adam Liptak, who is the Supreme Court reporter for the New York Times. He is, among his distinctions, he's a Pulitzer Prize winner. He has both a BA and a JD from Yale. My favorite little biographical note about Adam, correct me if this is incorrect, but upon graduating from Yale College cum laude, his first job was as a copy boy.
That's correct.
It's nice to hear that Yale prepares people for careers of that sort. So, and then on the far end, here's Kenji Yoshino from NYU itself. He is the Earl Warren Professor of Constitutional Law here at NYU. He began his teaching career, taught for 10 years at a much smaller law school up in New Haven that would go nameless if I hadn't already named it. He has his educational background is pedigreed as it can get. Harvard BA, Rhodes Scholar at Oxford, and then JD from Yale. So these are our panelists, and we're going to talk about. We've picked out what we think are the 8 most interesting and important cases of the term. We're going to talk about each of those for a certain period of time and hope that we have time at the end for comments and questions from the audience. We're going to begin with probably the biggest blockbuster case of the term, which is Masterpiece Cake Shop, and Kenji is going to tell us about the case.
So thank you so much, Michael, and it's a great pleasure to be here for the first Latham and Watkins Forum. So let me just begin by setting out the guts of the case. The same-sex couple walks into a cake shop. I know that sounds like the beginning of a joke. And they ask for a wedding cake. Same-sex marriage is not recognized at the time. This is 2012 in Colorado. And the cake shop is in Denver. And the cake shop owner, Jack Phillips, says that he does not provide wedding cakes for same-sex couples because of his religious convictions. He does articulate that he's willing to sell anything off the rack or shelf to gay people, so that if this were a matter of pointing at a baked good on a shelf, that would be fine, but that he is not willing to do anything that would imply endorsement or celebration of same-sex commitment ceremonies or weddings. So the couple was planning to get married in Massachusetts, which at the time did recognize such marriages, and then to have a reception in their place of residence, which was in Denver. They were later able to obtain a cake for free from a baker who said, I heard that this happened to you, and I want to engage in some amelioration, and provided a wedding cake for them. They nonetheless said that they felt that they had been discriminatorily treated by the cake shop, and so they sued Masterpiece Cake Shop under state law, because unlike federal law, Colorado state law has a non-discrimination provision that covers sexual orientation in public accommodations, which would include any business holding itself out to the public. They prevailed in the Civil Rights Commission, and then successively in appeals to the Colorado State District Court and the Colorado Court of Appeals, which gave perhaps the most elaborated opinion on the subject. The Colorado Supreme Court denied review, and they sued, or they appealed to the United States Supreme Court, which interestingly had sort of passed on taking earlier cases of a similar nature. There had been previous cases like a photographer or a florist who had said that they couldn't support same-sex couples in these ceremonies, and the Supreme Court had punted on those cases, denying review. So for those of you who are first years among us, the Supreme Court accepts review in about 1% of cases that are petitioned to it, and so even though you have an appeal as of right to a federal appellate court, you have no such appeal as of right to be heard on the merits to the United States Supreme Court. However, they did take this case, and the two issues that are presented in the case are first a religious discrimination claim, and second, freedom of speech claim, so two different parts of the First Amendment. The free exercise claim is an interesting one because in 1990, the United States Supreme Court said that if a law is of general applicability, right, meaning that it is not directed against a particular religion and doesn't mention religion on its face, then nothing more than rational basis review will apply, which is the lowest level of scrutiny that the court will give to legislation. It has said in a subsequent case that if there is a clear sort of underlying animus that was animating the facially neutral statute, that that would be intentional discrimination and therefore would trigger a much more stringent test. But that does not appear to be the case in this instance, given that the Colorado non-discrimination law was not enacted in order to attack religious objectors to individuals who were LGBT. So what they need to do is to find a way to create a claim even in the backdrop of the Smith case in 1990. And what they have argued is that Smith distinguishes an earlier case called Wisconsin versus Yoder, saying that where there is a religious claim combined with another kind of claim, in Yoder it was a free exercise claim combined with the right of parents to exercise control over their children's education, where there's a hybrid claim, that claim should fall into an exception under Smith. And here they said that there was a hybridity in between the religious claim and the speech claim. But I take the religious free exercise claim to be relatively weak compared to the speech one. And one thing that's critical here is that there is no Religious Freedom Restoration Act statute. So many of you might have remembered the Hobby Lobby case decided a couple of terms ago. And I want to underscore that in this case, the federal Religious Freedom Restoration Act does not apply for reasons that we can go into in the Q&A. And then there is no state cognate of the Religious Freedom Act. So many states have enacted mini RFRAs, so to speak, but Colorado is not one of those states. So they're really relying for their religious discrimination claim, the cake shop is, on the constitutional free exercise claim alone. The second part of this case is the free speech portion of it. And the notion is that there are certain industries that are expressive, right? We were talking at lunch about whether or not you should be able to go to a poet and say, like, you write poems and you hold yourself out as a, poetaster to the general public, and so therefore you should write me a poem, that you should not be able to control that. And the cake shop is making such a claim with regard to its expressive freedom under cases about compelled speech by the government. So if you think back to the 1970s, those of you who are familiar with this case law might remember a case called Willie versus Maynard, in which a Jehovah's Witness, George Maynard, said, "You can't force me to carry on my license plate the New Hampshire slogan, 'Live free or die,' because that contravenes my religion, but it also puts words in my mouth. It's the government forcing me to utter things that I don't actually believe." So similarly here, the idea is that the Colorado non-discrimination statute puts words in Jack Phillips's mouth as the proprietor of the cake shop and forces him to use his artistic talents in the name of something that he truly doesn't believe in. So there are difficult questions on both sides, right? So the difficult question on the side to be asked to the LGBT couple is, okay, why isn't there a kind of live and let live kind of scenario here where nobody is saying that same-sex couples are being denied now the nationwide right to marry? If we really believe in true tolerance and diversity and letting 1,000 flowers bloom in our incredibly diverse nation, then why wouldn't we allow individuals to opt out on speech grounds from saying things that they truly don't believe, especially since there are sort of market-based solutions to this. If you're a cake shop that becomes known as someone who doesn't cater to the LGBT community, then there are likely to be swift sanctions of an economic nature so that this legal sanction is redundant, right? So that's the question to be posed to one side. The question to be posed to the other side, I think, is, well, if we allow this expressive exception to non-discrimination laws, then is there a religious right to discriminate or an expressive right to discriminate that is so wide-ranging that a baker could say, I don't want to create a cake for an interracial marriage, I don't even, under the theory of this particular case, I don't even need to articulate a religious belief. I just need to say on expressive grounds, you're forcing me to say something that I don't believe in, even if I am expressing that on a cake or as a florist or as somebody who's holding out a venue to a same-sex couple or an interracial couple, right? So in effect, this becomes a religious or expressive right to discriminate that could gut civil rights protections across the board. So I'll pause there and ask my colleagues if they think that's a fair rendition of the case.
Well, let me ask you about a particular fact in the case that I think is interesting, which is that there were some folks who asked bakers in Colorado to bake anti-same-sex marriage cakes, two different occasions, and the Colorado Supreme Civil Rights Commission said that those bakers did not have to make that cake, so it's like the opposite cake,
right,
on the ground that message was offensive.
Right.
Isn't for the government to say, well, your belief is offensive, mine isn't, so we're going to have somebody gets free speech rights and the other doesn't, isn't that pretty hard to justify?
Yeah, so there have to be limiting principles, and I agree with you that the Colorado's appellate court, which is the final disposition of that case, deals with that by saying that message is not as integral, right, that's about the message, that's not about the people. But I think I had the same qualms that you're expressing with regard to that, right? So when we go to that takes us to the interracial marriage case of shouldn't everyone be able to. So I guess the question I would ask back to you is say, yes, that troubles me, right, that distinction. But if I were to ask the question back about the interracial couple, does that mean that if we're not allowed to, talk about messages at all, does that mean that individuals who are bakers who say, I don't believe in interracial marriages because of my religion or because of my expressive beliefs absent religion, that they too would be able to refuse African American individuals.
Well, if you're asking me that, I think yes. I think racists have free speech rights just like everybody else.
Mm-hmm.
But to go back to your question, Michael, about whether the anti-gay message has the same protection as the celebrating of gay marriage, I think you have to go back to the underlying state law, which is an anti-discrimination law that protects various categories of people. It protects gay people. It doesn't protect bigots.
But I think what Michael's saying, well, I mean, Michael can tell me if this is what he's saying, but what I intuit underneath that is that the anti-discrimination law does protect religion. And so in that particular case, that individual was saying, give me a Bible that is open to the page in Leviticus that condemns same-sex sexual activity. So if religion is protected under the Colorado law in the same way that LGBT rights are protected, then I think the analogy holds true. Is that where you were going?
Well, yes, although I think the free speech claim doesn't depend on it being religious, but I do think that the bakers, that these folks in the anti-same-sex marriage people would say that our message is just as integral to our religion as
Exactly, right.
the message here is to same-sex discrimination against people. Melissa, do you have a reaction to this case?
I do. I mean, I think you did a great job covering the merits of it. And I mean, it's a hard case, and you know, frankly, it probably comes down. You all can disagree with me, but I think it comes down to where Justice Kennedy is on this issue, sort of becoming a familiar refrain in recent terms. But it's a hard one for him because it pits where he is on First Amendment issues with where he has been on gay rights issues, and it really puts them up against each other. And it's for me, it's a little bit hard to predict where he lands on that. I think the interracial marriage problem is a really big one. I think he would be very uncomfortable saying that it would be okay for a baker to decline to provide a cake for interracial marriages, and I think it's hard once you get to that point to draw a line there. I think that's probably one of the bigger issues in the case, and I would be surprised if it didn't come up at argument because it seems like a big question, but I think it probably does come down to that balance, and I agree that it seems like the sort of speech expressive component of the case is much more likely to have traction for the baker than the religious component.
So shall we move on to?
I'm going to add just one more word to answer a question Kenji posed as a hard question for one side about whether this harm isn't kind of de minimis. And, you know, go across the street, get somebody else's cake. Why make a federal case out of it? I was out in Colorado a couple weeks ago. I interviewed the baker. I interviewed the gay couple. And they were both sincere, and it made the case seem harder, not easier. But one thing that was perfectly plain to me is that the couple shows up excited, wants to get a wedding cake. One of their mothers is along with them. And when they're told, you know, your kind isn't welcome here, it was deeply humiliating, embarrassing, distressing, an authentic harm. And I was not unsympathetic to what even some of my liberal friends said about the cake. It's only a cake, you know, get a different cake. This experience they went through was authentically wounding.
Right. Yeah, so it's a dignitary claim, but it's a dignitary claim on both sides. So what's fascinating about this is that in the 1996 case, the Romer case, Justice Kennedy was writing about how, you know, this is, you know, a culture war, a Kulturkampf. And what's fascinating about it is that as the LGBT rights movement has progressed, the question of who gets to emerge from the closet or enter the public sphere and who is pushed out of the public sphere and has to enter the closet is fascinating. And I think because religion, like sexual orientation, is an identity where you can both pass and convert, right? That the kinds of harms that can be inflicted on both sides are greater, right? And so what we're trying to decide here is really who gets a place in the public square, right? And you saw elements of that in the dissents of the same-sex marriage case, particularly in Justice Alito's dissenting opinion, where Justice Alito was talking about how opposition to same-sex marriage can now only be voiced in the privacy of one's home, and that was the kind of closeting rhetoric that he was describing, right? And so if you are a, you know, ardent, LGBT rights advocate, this is just simply about there's no religious right to discriminate. This is like racial discrimination. It needs to be stamped out. It's actually a little bit more complicated than simply saying racists have rights to free speech as well, because it's one thing to say the Nazis get to march in Skokie. It's another thing when there are goods and services, right, attached to it as well. So this is not pure speech, right? So it's complicated a little bit by that. But I think I just want to sort of pan out a little bit and look at the broader stakes of this. This really is a culture war where, or a closet war, if you so to speak, where one side is emerging from the closet and the other side feels like it's being pushed into the closet.
I think also, Kenji, you mentioned, this is not a pure speech case. So another issue I think that the case raises is how you define expressive conduct, and the public accommodation law covers all kinds of goods and services. So renting of banquet halls, the florist, the photographer, you can kind of go through a very long list of public accommodations. And if there's an exception for expressive conduct based on the First Amendment, how far does that go? What do you define as expressive? I mean, this is the, cake is art case, which, I could see the argument there, although whenever I say it, my initial reaction is that it's a stretch, but if you think about it, it makes a lot of sense. I mean, there are really artistic, beautiful cakes out there, and I'm curious when you met with the
They're nice
baker,
cakes.
from what I've seen. But how far does that go in terms of like decorating the banquet hall and where you go from there? So I think the brief from the United States in this case, which is on the side of the baker, draws that line or tries to draw that line, and it's one of those that when you articulate it, it makes some sense, but I think it's a little bit harder in practice than it is when you just explain what the rule is.
Absolutely.
So let's move on to Gill versus Whitford, which is the case about gerrymandering. And Adam, would you?
So the court's going to hear this case on the second day of the term, October 3rd. It's one of many cases which looks at the curious way that the United States conducts its elections. Unlike most of the rest of the world, it allows elected lawmakers to draw legislative maps, those weird shaped maps, after each decennial census. And what lawmakers do is do everything they can to extend their own power, to make sure that in subsequent elections, people in their party will get elected. The Supreme Court has said that racial gerrymanders may be unconstitutional, but it's never struck down a political gerrymander. This case arises under fairly extreme facts. In 2010, after, for the first time in 40 years, Republicans captured every part of the Wisconsin state government. They drew, assisted by computers, Republicans there drew some very aggressive maps, so much so that in the next elections, Republicans won 48.6% of the statewide vote for the state assembly and captured 60 out of 99 seats. That is 48.6 translates into more than 60% of the seats. Some Democrats challenged this, and for the first time in more than 30 years, a three-judge federal district court strikes down the map as a partisan gerrymander. That gets appealed to the U.S. Supreme Court, where some people who have questions about running an election system in this way are hopeful that maybe finally the Supreme Court will do something about it. And here, and we will say this over and over again, it really depends on Justice Kennedy. In an earlier case, and this, for curious reasons, this tends to divide along partisan and ideological lines with more conservative and Republican appointees thinking about this issue one way and more liberal and Democratic appointees another. Not really clear why, because both parties do it when they can. It's just that recently Republicans have been in power. In the 80s, Democrats went crazy on partisan gerrymandering. And Justice Kennedy's in the middle. Justice Kennedy goes, I don't think this is a great thing. I might be inclined to do something about it, but I can't think of what the administrable standard would be. And the innovation in this new case is that a law professor at Chicago and a political scientist have come up with what strikes me as a fairly clever numerical standard. There's a little math involved here, and you don't have to follow it, but what you do is you take every excess vote, every wasted vote. Let's say you pack all the Democrats into one district. Every vote after a bare majority of Democrats is a wasted vote. You crack Democrats across other districts, so Republicans have a slight majority, enough to elect a candidate, and Democrats are in a slight minority. Every one of those votes is a wasted vote. You add up those wasted votes on both sides, you divide it by the total number of votes, it gives rise to a ratio, and the ratio in Wisconsin is quite extreme. So here we have a standard. There's also a legal test involving intent, effect, and whether other factors played a role, and many factors play a role. Drawing maps is not easy. You take account of things like contiguity, counties, incumbency, all kinds of other factors can make a difference. And there are natural distributions of Democrats and Republicans in Wisconsin and elsewhere. Democrats tend to pack themselves into cities, putting themselves at a disadvantage in this kind of thing, even if there is no partisan gerrymandering. But nonetheless, there's good reason to think that Wisconsin did something to give Republicans a really lopsided advantage. And it may be in this case that Justice Kennedy will find the administrable standard and will say, hey, I don't know where the line is, but this is certainly over the line. Two reasons to think he might not be ready to go, or maybe three reasons. One is you might think the court indicated some interest in the case because they agreed to hear it. As Kenji was saying, they hear very few cases, but on their discretionary docket. But these election law cases arise on the court's mandatory appellate docket, so they more or less had to take it. And as soon as they took it, by a 5-4 vote, they stayed the lower court decision, and Kennedy plus the conservatives were in the majority. So those are two reasons to think Kennedy might not be ready to go. A third reason is last night, again by a 5-4 majority, again with Kennedy joining the conservatives, the court stayed two redistricting decisions in Texas. So liberals and Democrats these days are hopeful that the court might finally be ready to move on partisan gerrymandering, but I think it's an uphill climb.
So I'm curious, why is this ratio of wasted votes actually, how does that provide a standard? Because there's no reason to think that the ratio of wasted, that the natural ratio is even. In fact, as you say, there's every reason, given current demographic situations where Democrats tend to be overwhelmingly concentrated in large cities. New York, for example, is what, I don't know, 80% a Democrat, and then with little pockets, usually college towns, heavily Democratic, and then Republicans tend to be more evenly spread over the remaining territory. Given that, there's the natural ratio of wasted votes is going to be pretty lopsided. Now, maybe Wisconsin is even more so, but how do we know what more so is, since we don't know what the natural, ungerrymandered state of the world would look like?
Well, I should say, first of all, that this numerical standard, this efficiency gap, is not anything either the district court or the plaintiffs put all of their weight on, but they say it's an indication, and they say when it gets above a certain level,
don't they
it
just
sure
say
is.
They say 7%,
I think
right?
they're retreating a little bit from drawing a
They
precise
just
line.
plucked that out of nowhere, right?
Well, you know, I mean, in one person, one vote, the court has said a 10% swing might be okay. I don't think 10% is in the Constitution either.
Can I just add to that, Michael, and say on Adam's side of this, you know, I agree with the intuition that it's strange to take the kind of soaring words of the Constitution and then derive, you know, very specific, granular, numerical standards from it, but it's not itself unprecedented. So if we look at, say, the punitive damages context, right, we see very open-ended language being cashed out by the court into things like 4-to-1 ratios or 10-to-1 ratios, which are not absolute rules, but which are guidelines for when a punitive damage award is too much, right? And I think that what's driving the court there is this notion that we have to go somewhere with this, right? Because even though we can't assume that there is a correct level of punitive damage in any scientific sense, in the same way that we can't determine what a fair election on partisan grounds would look like in any kind of absolute sense, we nonetheless have to do something here because under any kind of reasonable view of what fairness would be, this is so out of whack that there needs to be some sanity restored to the process.
I mean, it seems that's where the threshold comes into play. I have no idea if 7% is an appropriate one or where it came from, but I mean, I guess if the idea or the argument is that what they're really trying to do is, first of all, in order to get Kennedy's vote, they have to come up with an administrable standard, and so no better way to do that than to actually, have a formula and put a number on it. And then I think the other pitch is to come up with a standard that really only addresses the most extreme cases, because I think otherwise you'd absolutely run into that problem, whether there is such a standard and whether 7% is it, I think is a really tough question, but it seems like in order to get Kennedy's vote, there has to be something that is more definitive and more administrable than what's been suggested in the past.
So let's move on to the next case, which is Jesner versus Arab Bank. Melissa?
Sure. So Jesner versus Arab Bank is a repeat case, and what I mean by that is this exact same question was before the court in a case called Kiobel in 2011. So this is a case about the Alien Tort Statute, which is a very old statute that allows victims of human rights abuses to bring suit in the United States. And so in 2011, the court took this case called Kiobel to answer the question as to whether the Alien Tort Statute, which is called the ATS for short, whether the ATS categorically prohibited claims against corporations. It granted cert on that question. The case was briefed by the parties. The United States filed a brief. I was at the SG's office at the time, and so full disclosure, I briefed the case for the United States at that point. So the U.S. filed a brief, everyone filed a brief. The case was argued before the court, and then I think it was about a week or so after the argument, the court changed their mind and decided they wanted to answer a different question entirely, which is when or whether the ATS applies to conduct that is extraterritorial, conduct that occurs overseas. And so the court asked for a briefing on that separate issue, heard argument again on that question, and ultimately decided the case on that basis and didn't ever decide the corporate liability question. Some may have thought, and I may have been one of them, that by resolving the extraterritoriality question and essentially cabining the circumstances in which you could bring an Alien Tort Statute, because they said that the claims had to touch and concern the United States, that the corporate liability question in some ways, not that it would go away entirely, but that it would become far less significant, because a lot of the cases that have been brought in this area kind of fell into that box where a lot was going on overseas. That turned out not to be the case in this Jesner versus Arab Bank case. Kiobel came out of the Second Circuit. The Jesner versus Arab Bank was also in the Second Circuit. And so it went back up to the Court of Appeals after the court decided Kiobel, and the Second Circuit said, in Kiobel, we said that you cannot sue corporations. We're going to say the same thing here. The Second Circuit denied rehearing en banc, and it made its way back to the court, posing the exact same question. And so the facts here, these are victims, and I think family members of victims of terrorist attacks by Palestinian organizations, and what they allege essentially is that Arab Bank, through its banks, including a branch in Manhattan, basically has helped finance terrorist attacks. That's the general allegations. But the legal issue in the case is whether you can bring an ATS claim against corporations. And parties in briefing this issue, it really comes down largely to whether you look to international law to answer that question or whether you look to domestic law. Oversimplifies it a little bit, but I think that's one of the key pivot points in deciding this case. And so the argument on the Arab Bank side is in a case called Sosa. The court said there needs to be an international norm that is essentially a consensus norm in order for you to be able to bring this sort of claim. And so Arab Bank argues that the same is true with respect to corporate liability. That is part of the substantive norm. You have to look to international law, and there's just no consensus that you could sue a corporation under international law. On the flip side, the other argument is, okay, yes, you look to international law for the norm, but what we're talking about here is the enforcement or the remedy, and for that, you really look to domestic law. And I think it seems that in terms of the facts that if you are going to look to international law, that's probably right, that there is no international law norm about suing corporations. And I think it's equally true that if you look to domestic law, it's very clear, both at the time the ATS was enacted and today, that there is a very clear norm or established practice of suing corporations. And so that seems to be the pivot point. A lot of the discussion has to do with a footnote in SOSA that makes it a little bit unclear what the answer to that question is. But one of the interesting things about this case as it's progressed and as it's been briefed, I should say the U.S. filed a brief again in this case and did so under the Trump administration and adhered to its position that it took in the Obama administration with respect to corporate liability. But the second half—
Which is what?
Oh, which is that, sorry, I didn't say that. So the view is that, yes, there can be corporate liability under the Alien Tort Statute. And so one of the interesting things, though, is the second half of the U.S. brief and a very significant portion of Arab Bank's brief says, okay, aside from the corporate liability issue, there are a lot of other issues here and a lot of other reasons that this case shouldn't go forward, including, remember that extraterritoriality issue you decided in Kiobel? Well, the Second Circuit, didn't decide that here, and that would be another basis to make this case go away, either by the court deciding it or by the Second Circuit deciding it on remand. And so, in addition to the actual questions that's presented, there is a little bit of a chance that the court could get out of deciding it again and look to one of the other issues that are raised in the case. I don't think it's as likely here, but that seed has been planted.
Can I ask you a question, Melissa?
Yeah.
So when I saw the Kiobel case argued, those of us in the press corps, this was not long after Citizens United, we thought, geez, are they really going to say that corporations can say what they like but can't be sued for torturing people? And then we thought maybe that's the reason they didn't want to answer the question back then. Is there anything to my intuition? And do you think there's been enough passage of time that the court can now answer the question on corporate liability pro-corporations without people like me writing that sentence?
On the second question, no. I don't think there's any chance that wouldn't be a very big part of the story were they to come out that way, and for good reasons. On the first part of the question, I think that's possible, although my feel is that the reason they ducked the issue was really for a fairly legitimate reason, which is that the other issue is kind of a bigger issue in the case and a bigger issue in the case law more generally, or at least potentially so. And so the argument itself, it eventually got around to talking about corporate liability, but it at least started off as having the justices say, oh, wait a second, you have, foreign plaintiffs alleging things that happened in a foreign country. I forgot, it was like foreign squared or cubed or something like that. It was like it was as disconnected from the U.S. As you can imagine in a case, and I think that's something that grabbed a lot of the justices when it first came through and directed their attention there.
So I'm curious about the ideological valence of this case, because in general you might think the leftward side of the court would be more interested in expansive liability for human rights violations. That seems right. But on the other hand, it's the rightward side of the court that are more likely to say, look at what the Alien Tort Statute says, and it draws no such distinction. And I think that they are likely to say, international law they're not as anxious to bring international law into U.S. law. So the rightward side of the court might actually favor expansive liability here, unlike Kiobel, where the ideology mapped onto the issue because conservatives tend to be suspicious of extraterritoriality, and that happened to be again. So I'm just wondering, because it seems sort of like there's this cross-ideological thing going on here.
I think that's true. I mean, I don't think it would be crazy to think that this case could come out really in a lopsided way, saying that there is corporate liability for the reasons you note, and also because there are other ways to dismiss these suits short of corporate liability. So for the side of the court that might want less expansive liability, there may be other ways for them to get there, short of deciding the corporate liability question. So I think it's possible that those two things could align. You're certainly right about the side of the court that would want expansive liability for corporations. During the argument, I don't know if you remember this, but during the argument, Justice Breyer was very focused on the possibility of Pirates Inc. was the example I think he used on 3 separate occasions. Well, what if there's Pirates Inc.? Are you saying, you couldn't sue the company? So I think, on one side you're definitely right, but I think you're right that the other side could lean that way as well.
It's an interesting, litmus test for Justice Gorsuch, whom we haven't talked about that much. But, if we think about where Scalia might have been torn on textualist grounds versus, say, ideological grounds on this case, we'll learn whether or not Gorsuch is similarly torn between a methodology and an ideology.
And when you think, so the Alien Tort Statute, you didn't really quote it.
Does it have the phrase, the
exactly
law
what
of
it is?
nations in it?
I think it has the word that people are focusing on right now is tort. That's in there. That's one of the focuses.
But I think I think you can be a conservative and still look at contemporaneous international law to see what the drafters of the Alien Tort Statute thought in whenever it was, 1781.
It's true. So this statute is passed by the first Congress. This goes right back to the beginning. The paradigm case that they were thinking of, not saying that that's all it's about, but what we know that they thought about was when a foreign ambassador is attacked in the United States, a tort is committed against a foreign ambassador because international law protects ambassadors, and all countries are under an international law obligation to protect ambassadors against private attack. Now, I think if a corporation attacked an ambassador, I mean, it's impossible to think of that in 1791, but I see no reason to think that either the text or the theory behind the statute would care that it's a corporation. Where the international law kicks in isn't who the tortfeasor is. The international law is about the fact that we are under an international law obligation to protect ambassadors. So I think a textualist with a historical bent should be on the side of the plaintiffs in the case.
I think that exact typo came up, that argument as well, about the ambassador, because it is what prompted the enactment of it. And particularly, I think that exact scenario had happened or something very close to it. And there was a really negative reaction from the international community as a result of it, and that's what prompted the passage.
So let's move on to another case that a few people might have heard of, Trump versus Hawaii, and consolidated with Trump versus International Refugee Assistance Project.
So these are the travel ban cases. They're going to be argued on October 10th. The procedural history has gotten fantastically complicated, and I'm going to try to breeze through it, and maybe the takeaway point is that after all this drama, it may be that this thing fizzles. So a week after he's elected, President Trump issues the first travel ban, causing chaos at the airports and a cascade of litigation. It barred travel from 7 predominantly Muslim countries and suspended the nation's refugee program. When that was blocked by the Ninth Circuit, instead of appealing to the Supreme Court, the administration issued a revised travel ban, not terribly different, in March. That was promptly attacked, and there are 2 cases we need to focus on. One comes out of Maryland, goes to the Fourth Circuit, and enjoins the law based on the Establishment Clause, on the theory that we know that what is really animating this order is animus against Muslims. And we know that because President Trump said so repeatedly during the campaign and afterwards in various ways at various times. He must be a terrible client to have. The Justice Department's basic response to that is, in the immigration context, you don't get to look beyond the 4 corners of the executive order. They say there's nothing on the face of the executive order that exhibits religious animus or discrimination, and also that the president has vast powers over immigration and national security. And so that's case number 1 going to the Supreme Court. Case number 2 out of Hawaii goes to the Ninth Circuit. The Ninth Circuit enjoins on different grounds, on statutory grounds, saying that President Trump has exceeded the authority Congress has granted him. The statutes are fairly intricate, but the one that seems to work best on the anti-discrimination grounds does forbid religious discrimination in the issuance of visas. But the issuance of visas, it does not cover everything that's going on here. People enter the country in various different kinds of ways. As all of this, and then the Supreme Court grants cert on the last day of the term in June, sets the case down for argument in October. When it grants cert, it says, in the meantime, we're going to lift part of the injunction. We're going to let the president exclude some people, but not those with a credible claim to a bona fide connection to an American person or entity. And then there have been constant disputes, including one resolved last night, about 2 parts of that. One involves who counts as a close enough relative. If you have a close enough relative here, do you get to come? And what we know from the Supreme Court is that a mother-in-law is clearly, the court says, a close enough relative. Now, if that's your touchstone, you may think you could pick up some other relatives, like, say, grandparents. I don't know, you're probably not, most of you, married, but you might be closer to your grandparent than your mother-in-law. I don't know. It does seem to me that at least one member of the court who entitled his memoir, My Grandfather's Son, might think that grandparents fall into that category, but not the Trump administration. So that bounces around the court system, and on that, the administration has lost and didn't even appeal the most recent version. Separately, though, on the refugee program, the administration wanted to and has succeeded in provisionally barring people whose connection to the United States was with a resettlement agency ready to help them when they got here. The administration's theory is, well, it's nice that you have some connection to this resettlement agency, but it's only because the government set up the connection and because there's an intermediary involved. That's not a bona fide relationship with the U.S. entity. And provisionally, and including last night, the Supreme Court says that's right. So that's what's going on in the interim. When we get to the argument, I would expect that a fair amount of it will be focused on the following question. These travel bans were not permanent things. They were pauses. One of them 90 days on the 6 nations in the second version, one of them 120 days on the refugee program. They were pauses to give the administration time to figure out what it really wants to do. The 90 days will have expired by the time of the argument, the 120 days soon after. And I would think that much of the questioning might focus on, what are we deciding here, fellas? Isn't this over? Isn't this moot? Shouldn't we get rid of it? Now, as the briefs come in from the ACLU and Neil Katyal and Hogan Lovells on behalf of the Maryland and Hawaii plaintiffs, they don't seem super interested in that exit ramp, but I don't think that's going to stop the justices from looking at the case. And I don't know that the court is eager to either rule for or against the Trump administration on this thing. So I would think that the exit ramp might be attractive to them.
And just to chime in on that last point about justiciability doctrine, again, for those of you who are just coming into law school as first years, one thing that is often counterintuitive to folks who are coming from other jurisdictions or who have dealt with state constitutions is that for federal constitutional purposes, there's a case or controversy requirement in Article 3, which means that you can't ask the court for an advisory opinion. It also means that the matter has to be live before the court. So ripeness and mootness are the doctrines that Adam is talking about. Ripeness means that the case has come to the court too soon. Mootness means that it's come to the court too late, right? And so in this particular instance, if there isn't a live issue before the court because both of the orders have expired by the time the court is turning to a decision, then the court could easily just dismiss the case as moot, and that's not a ruling on the merits, right? And creates no precedential value. So just because you want the court to say this is beyond the president's powers or this is a violation of the Establishment Clause does not mean that it is going to, feel incumbent to answer that question in the absence of a live dispute between the parties.
Now, if they dismiss as moot, will they vacate the lower court decision so that they also will have no precedential authority?
That is disputed in the briefs, and the government if dismissed, would like the appeals court decisions to go away. The ACLU in Hawaii take a different view. The case that controls, I think it's called Munsingware, and it seems to turn on, did the party seeking the vacatur put itself in this position by not acting fast enough, for instance? And interestingly, when the government sought cert from the Supreme Court in the late spring, a lot of people thought they would ask for expedited treatment. Wouldn't be so unusual. Happened in Dames and Moore, happened in Pentagon Papers. The court would probably have accommodated them with a July sitting. But instead, they set it down for October. And if they themselves were the instruments of making the case moot, perhaps they're not entitled to the vacatur they seek.
So in order to have time for questions, let's rush through. We have 4 cases, but if we could just spend no more than about a minute, just a quick introduction to what they are. Melissa, would you tell us about NLRB versus Murphy Oil?
Sure, I will try to stick to my minute, but maybe like a minute and a half.
That's 10 seconds.
So this is the good point. This is the first case that the court's going to hear this term. It's a big one for employers and employees. It's about whether or not employers can have employees agree to individual arbitration, which means if there's an employment-related dispute, you have to arbitrate it, and you can't bring class arbitration, which essentially means there would be no class actions for employment-related disputes. It's a huge issue. This is 3 cases that were consolidated for argument. It is really interesting on the merits. It puts the Federal Arbitration Act, which is pro-arbitration, against the National Labor Relations Act, which allows for concerted action, prohibits employers from preventing such concerted action. What is really interesting about the case for me, in addition to the merits, is this is one of the cases that the United States has changed its position on. One of the 3 cases, Murphy Oil, the U.S. itself petitioned for cert when it had lost the case below, and that's because the National Labor Relations Board had taken the position that you cannot have these sorts of agreements, that it's an unfair labor practice under the NLRA, which is the statute that they administer. And so that had been the position of the government going into the term. The SG's office, the United States, changed its position. So this is a case in which the United States, through the SG's office, is arguing that you can have these and that it is not a violation of the NLRA, that it's, you can have these arbitration agreements. So they're now on the side of the employers. The NLRB is still in the case. They're one of the few agencies that can litigate before the Supreme Court without being behind the SG's office. And so they are still in the case arguing their same position. And so they're on the side of the employees. And so the argument, I don't think the court has acted yet on the motions for divided argument, but this is an hour of argument where you're going to have the U.S., the employer, the employees, and the NLRB making their arguments before the court. So it'll be a really interesting case, an interesting argument. I have a lot more I want to say on it, but I will leave it at that.
Kenji Carpenter?
Yes, so this has to do with the Fourth Amendment's doctrine with regard to what's known as the third-party doctrine. So you don't need a warrant in order to engage in gathering information as a police, so long as that information has been voluntarily disclosed to a third party. So the cases that set this expectation are Miller in 1976 and Smith in 1979, and the idea is that if you provide information to a bank or to a phone company, then you've done that voluntarily, and the police can access that because you've assumed the risk in voluntarily disclosing that information that the police will be able to access that information. That's a pretty gross simplification, but we'll leave it at that for these purposes. What has happened since the 1970s, obviously, is a massive digital revolution that has called the third-party doctrine into question. And indeed, in a recent case, Justice Sonia Sotomayor said it may be time, because of the digital revolution, to completely rethink the third-party doctrine, and indeed whether it should exist at all. This comes into play in the Carpenter case because what happened in Carpenter was an individual was tracked through his cell phone with regard to his location. So the contents of his cell phone remained private, his calls remained private, but his location was detected by his propinquity to cell phone towers that were picking up reception from his phone. And so the question is whether or not that was a disclosure, right, of his location to his cell phone provider, such that the government could access that information to figure out whether or not he was a mastermind behind a series of robberies concerning, of all things, cell phones. And so because this occurred in a relatively wide geographical space across at least 2 states, where he was at a particular time was quite salient in his conviction. He was convicted and sentenced to 116 months in prison. So the stakes are quite high here. There have been 2 intervening cases that cut against the third-party
brief,
doctrine.
please.
Yep. So one of them is the Riley case. The other one is the Jones case, for those of you who are looking, want to look at this more closely. But the only thing that I'll say, because my time is short, is that Chief Justice Roberts said, essentially, we're all cyborgs now in one of these cases. Like, we carry our cell phones everywhere. And so it may require that we update our disk with regard to doctrine that was established far beyond the advent of this digital technology.
Melissa, Oil States Energy Services.
Okay, so Oil States is a patent case, but it's one that has involves issues of constitutional law that go far beyond patent law. In 2011, Congress, through the American Invents Act, created what is called inter partes review, IPR, proceedings that allow any individuals basically to challenge patents as invalid for certain reasons through this administrative process that was specifically designed to be faster and cheaper than the way you normally would invalidate a patent, which is you go to an Article III court and you ask the court to declare that the patent is invalid. These proceedings are quasi-adjudicatory, but they're before an administrative agency and they're before a panel called the PTAB, which is within the Patent and Trademark Office. So the issue in this case is whether or not that procedure and that proceeding violates Article III, whether when you are declaring a patent invalid, whether you have to be before an Article III judge, and secondarily, whether there is a jury trial right in these circumstances. And so since 2011, this has been a process that has been utilized a lot by patent lawyers. There have been a significant number of patents that have been invalidated. This is a court that at least some justices on the court think that is probably a very good thing. There's been a lot of patent law going through the Supreme Court lately, and Justice Breyer in particular and others, I think that sometimes too many patents are granted. At the same time, this is also a court that fairly regularly reverses the Federal Circuit. This case went up through the Federal Circuit. The Federal Circuit said, yeah, no constitutional problem, this is fine. And now it's made its way to the court. Without going into too much detail doctrinally on the Article III, and I will do this in 2 sentences, one of the questions is whether this is a public right or a private right. In a case called Stern v. Marshall, which is one of the Anna Nicole Smith cases that made its way to the court spoke about it in a way that essentially said there are 6 or 7 different tests. We're not going to pick one next case, and so in this case, I think there will be a little bit more concentration on exactly how you decide when you need an Article III judge and when you don't.
Jennings.
People spend a long time, years, in immigration detention. And the Ninth Circuit said, well, once in a while you have to ask the question, can we let them go on their own recognizance? If they pose no flight risk, if they pose no danger to the community, why are they locked up? Why can't they wait with their families while we decide if they can stay in the United States or not? Ninth Circuit says this on statutory grounds, goes to the Supreme Court. The Supreme Court hears arguments, doesn't seem very interested in the statutory question, but says, hey, maybe there's a constitutional due process right here. Asks for further briefing, and then splits 4-4. Sets the case down for re-argument, and next month the court will hear argument on whether you have a due process right if you're in immigration detention to have a periodic bail hearing, not to be let go, just to be able to make your case that you shouldn't be held for years and years when there's no good reason to hold you.
We might have time for 2 questions or comments, so please raise your hand and don't speak until you're given the microphone, because this is being recorded. Microphones are being moved around. I see a hand there, if somebody could get a microphone to her.
Hi. This is going back to the question of the Alien Tort Statute. Despite the Kiobel ruling, you could arguably say that the Second Circuit ruling on Kiobel, saying that corporations can't be liable, is an outlier among other cases that have been ruled by various circuit courts around the country for the last 10 years. Ninth Circuit, DC Circuit, Seventh Circuit have all said that they can be, corporation can be held liable under the ATS. So do you think those will be persuasive in affecting the Supreme Court's decision, or will the extraterritoriality ruling from the Supreme Court in Kiobel kind of render those moot?
I don't think it renders them moot. I mean, I think that's why the court took the case when it first did in Kiobel about corporate liability, because there was a circuit split, and the Second Circuit, if I remember correctly, was standing alone then, and I think still is. I think the other decisions going the other way will be sort of persuasive to the extent the reasoning is persuasive. The way is true in most cases. There are definitely plenty of examples where the court has taken a case where there's been a very lopsided split and has sided with the minority. So I think they're persuasive to the extent their reasoning is persuasive. But at this point, with all the briefing in the court, I think there will be a lot that has been written on the subject that picks up on those opinions, and they'll look at it on the merits.
Thank you.
More? Am I not seeing any hands? Not seeing any hands, then let me just ask you to join me in thanking the panel for the presentation.